News Talk 630 WMAL, where you don't miss a thing. And we are back on Law Call. We are here today with attorney Leizer Goldsmith from the Goldsmith Law Firm representing employees. Attorney Tom Coleman is here from the firm of Williams, Mullen, Clark, and Dobbins representing employers. If you have a question or comment about discrimination in the workplace or any other legal issue related to your work life, you can call us at 202-432-WMAL, 432-9625. If you're not by the phone and would like to get in touch with the attorneys anytime during the week, you can call us at 1-800-LAW-CALL. There's a keypad there, and you can choose which firm you would like to speak to. And in just a moment, we're going to find out the outcome of a very interesting case where a promotion goes to a coworker who's sleeping with the manager. Do you have a situation where you can file a sex discrimination claim? We'll find out about that in just a minute. We're going to get to an anonymous caller in Virginia now, but before we go to the call, Leizer, I want you to set up the context of the legislation that this person wants to discuss.
Sure, Rick. Back in 1996, there was an attempt to pass a minimum wage bill in Congress, and some members of Congress insisted on including a rider on that bill that made damages awards won by employment discrimination victims taxable, which they hadn't been before. And there is now an effort underfoot in Congress, supported by many Republicans and Democrats, to try to reverse this. The bill would basically do three major things. Would make these damages that people win in discrimination cases not taxable anymore. It would allow for income averaging, so if somebody gets a whole lot of damages money back several years after they were discriminated against, they would not be in the position of having most of it go to taxes because of the law requiring the payments based on income in the year in which they are obtained. And also it would eliminate the double taxation that currently is placed on attorney's fees in these cases. So many of us in the bar are taking a position in favor of this and trying to lobby Congress and get Congress to change the inequities in this law, including many of our friends over on the defense side who realize that these cases are tougher to settle and more expensive for employers when the tax hit is so big.
Well, Leizer, you're absolutely right. I think you could argue this from a public policy standpoint, but employers are in favor of this because it does make it easier to settle these cases because the plaintiffs get to take home and keep more of their money.
So let's go to our anonymous caller from Virginia. Hopefully you'll pick up the cue here. Hello?
Yes.
And you had a question about the legislation.
I just want to know, why aren't they just pushing it more, the lawyers?
Well, the lawyers are pushing it very hard. I can tell you that the National Employment Lawyers Association, the plaintiffs' bar organization nationally, has made this a big priority. The day before our national convention, which happened to be in Washington this year, we went out and had a lobbying day, went out and met with many members of Congress. Right now Congress is, they're out of session or about to be. And in the fall, we're going to make a major push to try to get this legislation passed.
The problem is there's so many issues that the plaintiffs' trial bar are pushing that this probably got lost in the shuffle.
This is our number one priority, Tom.
Okay, here's a dicey one, gentlemen. Situation where a person is passed over for a job promotion. The promotion went to a coworker who's been sleeping with the manager. Tom, is there grounds for a sex discrimination claim here?
Well, surprisingly enough, and I think correctly, there isn't grounds for a sex discrimination in that particular context.
What?
And the reason is that this person who got the promotion got ahead, not necessarily because of her sex, but because of her relationship with the boss. And it wasn't based on sex discrimination, but based on her relationship with the boss. And most courts that have been confronted with this situation have said this is a relationship problem, it's not a sex problem. So sex is not always sex discrimination in the workplace. However, I want to add a caveat here. Most employers are concerned about even these consensual relationships in the workplace, particularly when it involves a supervisor and a subordinate. Because even though consensual relationships are generally immune from the sex discrimination law, once that relationship goes sour, you can expect to find some type of a sex discrimination claim. So many employers have have developed policies for policing these and monitoring these romantic relationships in the workplace.
Leizer, let's say Tom's right, and you can't get a sex discrimination suit. Is there
But he's
something
not
you can
right.
do? Something you can do about this?
Rick,
It sounds unfair to me.
You got to give me a shot at this before you assume that he's right. He's not right at all. There are some decisions. He used the phrase most courts. I don't know about most courts. There are some decisions that go that way. But right here in the District of Columbia, we have what Al Gore would call controlling legal authority that says to the contrary.
Al Gore was wrong on that too.
Well,
there was controlling legal authority
here
the other way around.
I have it right in front of me, Tom. 1985 case, King versus Palmer. The D.C. Circuit says there's an actual ongoing sexual relationship between the person who eventually gets selected and the selecting official. That's sex discrimination. The employee prevailed in that case and could win any time as long as they can show that that relationship was really going on.
Leizer,
so I disagree with you
You had to
greatly.
go back to 1985. The law has come a long ways since then, and fortunately there's a lot more enlightened courts that have ruled on the issue. This is not sex discrimination. This is a relationship between the boss and another female employee. The complaining female employee didn't lose, wasn't penalized, and wasn't discriminated against because of her sex. She was passed over because she didn't have that relationship with the boss. Now, that may not be a good thing. It may not be a proper way to run a railroad, but as far as I'm concerned, in a lot of other courts, that's not sex discrimination.
That's a game of semantics.
In violation of the law.
That's semantics.
I got to break it up again, guys. Sorry about that. We'll be right back. Stay with us on WMAL's Law Call, where you certainly don't miss a thing.
Hi, William.